Uh, Today we are going to discuss one of the most important topic which we normally encounter with asking questions on FIR and in the new criminal law. You must have seen comments etc. from the different groups, politicians that we have made a revolutionary change concept of E-FIR. So we'll look into the FIR and investigation. This is the topic which we are going to cover, uh, which is on FIR, zero FIR, etc., preliminary inquiry, then investigation by the police. Now, remember within criminal justice system, this investigation play very significant role, particularly investigation when police do investigate the cases. So there is a specific chapter in the BNSS on CRPC on investigation. So chapter 13. When you look at the old law, it was from 154 to 176 in the CRPC. BNSS, this chapter is from 173 to 196. That's the broad area of today's deliberation. So we are going to discuss from 173 to 196. 173, the first section, we talked about FIR and the new changes there on concept of E-FIR, Zero-FIR, etc. What we see from the new law. Many changes are there, and we'll see them. So, but what a good thing is, if you see the arrangement of the chapter, which starts from 173, and in bracket you will find the CRPC section 154. So you will find the arrangement was it almost same. What was there in earlier law, only that many number of sections are there in the new law. So by and large, same in content, we find some changes in section wise, and that we are going to discuss what are the changes there in each of the sections. So there we will find the changes which are being made in the new law. First and foremost, the FIR 173. Earlier also it was used the word information in cognizable cases. That's the concept was. So when we have done the classification of offences in the first class, the definition when we discussed, we know what the cognizable offences are. Where we will find the list of cognizable offences. So cognizable offences means offense where police can take action, and there are three kinds of powers are there of the police. They can register FIR, they can investigate sumoto, they can submit police report, etc. Charge sheet after investigation. So 173 clause 1, if you see, the red color which you find is a new addition in the new law. So every information relating to commission of a cognizable offense, first part, comma, irrespective of the area where the offense is committed. This is new addition. When it's using the word irrespective of the area where offense is committed, that basically concept of zero FIR. A informant or victim can register FIR in any places throughout the country. That's why we said irrespective of the area where offense is committed. So wherever offense might have been committed, FIR has to be registered by the police in any places. Then it very clear term says this FIR or this information which given to the police, it may be given orally or by electronic communication. Now, by electronic communication, this is new. Again, it was not there in the CRPC 154. And that's what many people's claims E-FIR concept of, because we are giving FIR electronic. However, in a real sense, it is not pure E-FIR. At least we can say some progressions being made. So, one orally, it was earlier also. So, if it is given orally, the officer in charge or other officer under his direction will reduce into writing, etc. And then that person will sign, and thereafter FIR is become FIR. When it is by electronic communication, then it is the additional requirement. And what is the additional requirement? The additional requirement is by electronic communication, comma, it shall be taken on record when by him applies OC, inspector. So it shall be taken on record by police, by inspector or OC officer in charge, on being signed. Who will sign them? The person who given this electronic communication. So the E-FIR concept, which is incorporated in the 173 BNSS, is not that you will send a fire and automatically it become a fire. The concept is someone can send by email to the police can write some good these things somewhere in the journal diary, etc. And then once the person maker of the statement will go to the police station, he will sign there. Once he signed, then that will record as an FIR. So in the real sense, it is not become automatically E-FIR. The maker of the FIR need to go to the police station, give the statement, and then only give sign the paper. And once the sign, then only it shall be taken on record. So we say E-FIR, but in real sense, still there is a requirement that the person who is giving FIR has to visit police stations and then they have to sign. And then it will be then taken into on record. So then the numbering, etc. of the FIR will be happening. And in such form, as the state government prescribed by rules, so we are going to still the rules are not being brought into, the rules is going to be place. Then this provision, it was earlier also, if it is about the sexual offences against women, rape cases, etc., then it has to be recorded by the women police officer or any women officer. If it is a person who is the informants are the disabled, physically challenged, mentally challenged, etc., then in those circumstances, the police has to go to the or it's requirement of the personal educator, and the police has to go to the residence of those persons for that. So those special requirements are there in these cases where the information is given by the person who are mentally or physically challenged, etc. In case of a person is a sexual offences and the victim is a physically or mentally challenged, etc. These are requirement that it should be there should be recording. It should be videographed, and then these statements should also be recorded by the magistrate under 183. Earlier it was 164 CRPC, now 183 CRPC. So there 183. These statements shall also be recorded. A copy of the statement recorded shall be given to the informant. Now here the word informant or victim. So very clear term it has used, it was not there earlier. So free of cost to the informant or the victim. Earlier probably they had used the word informant, now they added informant or victim. Both the words are there in this section. Now we come to very uh, in my sense very disturbing provisions they have included. It was not there under the old law. And my impression is these provisions will create difficulty for common man, villagers, for the poor people who cannot influence the place. So clause 3 says, and the first time the BNSS has incorporated this principle of preliminary inquiry. So let me just go through the provisions. Clause 3 says, without prejudice to the provisions contained in 175, 175 is the magistrate power to direct the police to investigate. On receipt of the information relating to commission of any cognizable offence, so when a police officer receives some information of cognizable offence, which is made punishable for 3 years or more, but less than 7 years. I don't know why the legislature has uses these 3 years to 7 years. One reason might be that more than 3 years, most of the offences are cognizable, but there are offences where punishment is less than 3 years, they are cognizable. So upper limit 7 years is understandable, but lower limit 3 years, so it could have only cognizable offences because there might be some offence where punishment is 2 years, but it's cognizable. Anyway, law says anything where the punishment is 3 to 7 years, it has given a margin to police that police officer may, with prior permission of an officer not below the rank of BSP, you can do preliminary inquiry. What is going to do preliminary inquiry? They will do preliminary inquiry to ascertain whether there exists a prima facie case or not. Within 14 days, they will do this preliminary. And if there exists a prima facie case, then they will proceed further. Now remember old 154 CRPC provisions, it was very clear, it says, if it is a cognizable offence, someone give information to the police shall record it. So there is a no bypassing provision, there is no way in which they can avoid registering FIR. Police was bound to register FIR. Now we have given a margin to the police that in cases where punishment is 3 to 7 years, instead of registering FIR, they can do some preliminary inquiry within 14 days' time. Some people give justification. This concept of preliminary inquiry started by the Supreme Court judgment. There is a case called, we'll find, let me see, Lalita Kumari. Lalita Kumari talks about preliminary inquiry, but Lalita Kumari talks about preliminary inquiry only for one purpose. For the purpose of understanding whether there is a cognizable offence or not. So to that extent, margin was available to the police to do preliminary inquiry to ascertain whether there is a cognizable offence or not. But the new law BNSS 173 gone beyond. A new law says it's not preliminary inquiry for this purpose, but new law says preliminary inquiry for ascertaining whether case is made out or not. That means evidence is there. Prima facie case is there. Remember this prima facie case traditionally we do, it used to be assessed by the court. When court frame a charge, on what basis? Whether there is a prima facie materials available or not. When court takes cognizance, on what basis? Whether there is a prima facie evidence or not. So the kind of or parameter on which the decision being taken, it was by the court of prima facie finding that these materials are there or not, case is there or not. Now the same thing we given to the police. My impression is what will happen. In many cases, the villagers, the poor people, their cases, the police will not engage. Police should not register FIR. They will avoid to register FIR. Now, in the circumstances when FIR was mandatory, we have National Police Commission report where Police Commission says that on many circumstances, police refuse to register E-FIR for different reasons. It can be corruption, it can be political pressure, it can be some other reason. It can be just for to control the data they don't register E-FIR. Law Commission also said the same thing, that police refuse to register E-FIR on many cases. In fact, there is a committee called Malimat Committee, and Malimat Committee was so annoyed that police many occasions refused to register FIR. Malimat Committee suggested that we need to change the entire concept of cognizability. So we need to make offenses, according to Malimat Committee report, they say that also we remove completely this list of cognizable, non-cognizable. We should make every offence a cognizable so that police cannot refuse to register FIR. We can make offences arrestable, non-arrestable. That was the idea of Malimat Committee. The background was that on many occasions, even rightful cases, police do not register FIR. That's the background. So in the circumstances, when it was a mandatory for the police to register FIR, we hear allegations on many occasions that police do not register FIR. Now, legally, we have given them margin, we have given them options that they can, instead of registering FIR, they can do preliminary inquiry, and if they find there is a prima facie case, they will proceed. So there might be cases where the case happened, but there is no prima facie evidence. Now, evidence collection is job of police. So instead of finding their own job, they may say, okay, no prima facie evidence will not proceed. This will bring a dangerous phenomena, and it will be denial of the right of the access to justice to the victims. So I think in the BNSS, this clause 3 is the worst thing which the law has included. In the yesterday class, I said section 105 of the BNSS, the best thing which has been incorporated for the citizen protections. In my view, the worst thing which has been incorporated in BNSS is clause 3. It will have its own adverse impact. We also talked about if every person by refusal on the part of the officer in charge. So the same thing which was there when earlier also it was there that when police refuse, what you will do, you send a letter to DSP. So here it says you can the same thing you can write to DSP, and then following which again you can go to magistrate. That too can work. Earlier that they added, but in the case these wordings were not there in the 154 CRPC. So failing which such every person may make an application to the magistrate. So it's talking about application under section 175. It was earlier 156 clause 3. So even though it was not written in the old law, but that practice was there. People if the 154 CRPC, if the FIR is not registered, a person can go to the magistrate under section 156 your CRPC 156 clause 2, under which they have a right to file the cases. They can file cases in their. So that's right are always available. In the old cases, when you find this mandate of mandatory FIR, in Hasil, the principal object of the first information report from the point of view of informant is to set the criminal law into motion, because the criminal law is bring into motion by this FIR. And from that point of view, the investigating authority is to obtain information about the alleged criminal activities so as to able to take suitable steps they will take, measures they will take for tracing and bringing the guilty party. Dharma Rama Bhagre. Now remember, if FIR is registered at the earliest point of time, it's always considered very important piece. Though it is not a substantive piece of evidence, it corroborates. So in this case, court says the first information report never treated as substantive piece of evidence. It can only be used for corroboration or contradiction its nature. or when he appear in court as a witness, its value must always depend on the fact and circumstances of a given case. Arnab Goswami, famous news anchor, and we know about his comment. There was a FIR through all the countries, Supreme Court clubbed together on FIR and then the directions for stopping further FIR. Lalita Kumari, so there though the Lalita Kumari judgment, Supreme Court that point of time says that there can be preliminary inquiry in certain cases. But primarily, Supreme Court says in that case that the cognizable offence, a duty has been cast upon the police to mandatorily register the FIR. The word shall is there in 154, the same word shall is there in 173 also. Shall given its ordinary meaning of being mandatory in character. The reasonableness or credibility of the informant or information is not a condition precedent for the restriction of FIR under 154. Whether it's a reasonable or not, credible or not, that's a police duty to find out. Police will collect evidence. But on that ground, we cannot refuse to register FIR. And that is the mandate of Lalita Kumari judgment. Gajanan Deshrat, many times when the FIR is delayed, it sometimes look at suspicious, but then law consistently says if satisfactorily explain the delay, why the delay was caused, it will not have any impact. So, if there is a delay in the registration FIR, there must be some justification, some reasons why that delay is being caused. And that's the consistently court says in many cases. That it says. So 123 talking about registration of FIR, and that's the beginning point by which our criminal law bring into motion. 174. What will happen if the information is about non-cop cases? We know in non-cop cases, non-cognizable cases, the police cannot directly investigate. So what the option is there? If they want to investigate, they can take permission from the magistrate. So one way is either they can take permission themselves from the magistrate, or they can refer the informant to magistrate. Nothing has been added, and that is a good thing. In clause 2, forward the daily value report of that those kind of cases, non-cop cases, fortnightly. Now, this is good thing. So, in cases where police is not registering FIR, on the ground that they are non-cognizable offences, there is a duty cast on the police that fortnightly they will give report to the magistrate all about those cases where the case disclosed non-cognizable offence. No police officers are investigating non-cop cases without the order of the magistrate. So they may also ask for the order of the magistrate. Any police officer receiving such information, such order may exercise same power, investigation except the power to arrest. So if the magistrate has given power order to the police to investigate in non-cop cases, then all the power of investigation except the power to arrest. Clause 4, very important thing. It was earlier also. Suppose in a case there are 3 or 4 offences. In these 3 offences are non-cognizable, one offence is cognizable. Then what will happen? Then clause 4 says the case becomes cognizable. So, where a case related to or more offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. So that also happened in many circumstances when in that way the case becomes cognizable. So Manohar Lal Sharma, order to conduct investigation police investigation of offences held is one of the important duties of the police has to perform which aim to search truth and bring out the book. There are many times when the questions come for re-investigations, trace investigations, and many times court do a law. Now, in fact, when we look at the charge sheet provisions, the new BNSS even says that even during the trial, if the trial is going on and there are new materials, the court may order for re-investigation. So that's power is there for re-investigation. Real Secretary of State of Bihar, case was transferred to CBI. Principal summarized related to when transfer of the investigation to CBI is permissible and warranted. So when a case can be transferred to the CBI. Ishwar Pratap, interference by court or external agencies. Now remember the investigation or arrest, etc. It is complete prerogative of the police agency. This is the investigation. So they have an independent power. Uh, so no external agency can dictate the course of investigation in a criminal case. It is within the exclusive jurisdiction of police. Court also cannot supervise investigation. However, in exceptional cases, superior court may monitor an investigation. So nowadays we see some cases investigated under the supervision monitoring of the High Court, monitoring of the Supreme Court. That different thing. They do in the exercise of their inherent power. Under the BNSS or CRPC, inherent power is vested with only High Court, not the lower court. So in that power, they can excite many things. But investigation work is a complete prerogative of the police, and accordingly, even court has a limitation. You cannot dictate. The suppose police will submit their police report. Now, what will be the nature of police report? You cannot dictate. The court cannot dictate. Police can submit either in the form of final report or in the form of charge sheet. So it is investigation is complete prerogative of the police department. Now we come to very important section 175. This section has frequently used. This section is about investigation or investigating power of the police. So 173 we have seen 173 was about FIR. But suppose, so when they have a FIR and power under which is FIR there, 175 clause 1 says the same police when they register FIR in cognizable cases, they power to investigate. So the power of registering FIR come from 173, to investigate come from 175. And 175 says any officer in charge of a police station may, without the order of a magistrate, investigate jurisdictions over local area within the limit of such station would have power to inquire into a try under the provision of Section 14. So the police does not require any specific order. In cognizable offences, they do have a power to investigate. So they can investigate the cases to moto or even on complaint on FIR. This is the new thing has been added. A proviso has been added here. Proviso says provided that considering the nature and gravity of the offense, the superintendent of police may require the DSP to investigate a case. So in some cases which are very serious in nature, SP may ask DSP to investigate. Now, although it was not written, but that does not mean that it was not practiced. SP has a power to assign the work to DSP. Even SP can investigate. There is no bar under the law. Remember in the old law CRPC 36, now the section number has changed. Whatever the power of an officer in charge can be exercised by all superior officer. It can be on PG also. So OC power can be exercised by superior officer goes up to DG. Clause 2 says no proceeding of a police officer in any case shall at any stage call for in question on the ground that the case was one which such officer was not in power under this section to investigate. That basically to give legitimacy to investigation. Clause 3, very important section. Criminal lawyers, magistrate court lawyers, bread and butter is this section and the women section. So here you will find what is written in the red color are new inclusion.
So clause 3 of 156 clause 3 now become 175 clause 3. These were the sections which frequently used. So when police refuse to register FIR, what's the remedy available to the informant, to the victim? One of the remedy was that they can go under 156 clause 3 earlier and file a case in a magistrate court, asking the magistrate to direct the police to register FIR. Now that section become 175 clause 3. Here also there is a change made. And what's the change made? So clause 3 says any magistrate empowered under 210. Now 210 is a cognizance provisions, which we have not discussed yet. After considering the application supported by an affidavit made under subsection 4 of 173, remember the FIR provisions clause 4, where it says that if the police has not registered FIR, the persons can contact magistrate. So under that 173 clause 4, persons contact magistrate and they will submit application with affidavit. But it does not stop there, and it says, and after making such inquiry as think necessary and submission in this regard by the police officer, impliedly before ordering to the police to register FIR and investigate, the magistrate will hear the police. Now this again, it will delay the process. It was not there earlier in CRPC. So it's a procedural obstructions created in making cases or registering FIR. Order such an investigation above mentioned, or court can order for investigation. So 173, we have seen some obstruction being created, inquiry. 175 clause 3 also we are seeing here, obstruction has been created when someone goes to the court for asking the court to direct for registration of FIR. The court will hear the police also, and thereafter court will decide. Now clause 4. This is about when someone reaches to the magistrate with allegation of some offences committed by public servant. So an additional safeguard is provided. It was not there earlier. I don't know how many of you have in news you have seen, probably when you was in first year or just high secondary, 4 years, 5 years, 4 years ago, one incident in Howrah. One day, there was some issue arises between lawyers and some police, and many lawyers were beaten by the police, etc. Now, these kinds of incident where public servants or the police involved in atrocity, remedies available is the persons can go to the magistrate, asking the magistrate to direct the police to investigate, asking sometime to direct the specialized agencies, DD, CID, etc. to investigate. Now, this is a new thing added, and the law says, this provision says, clause 4, any magistrate empowered under 210, that means cognizance provision, may, upon receiving a complaint against a public servant arising in course of the discharge of his duty, order investigation. They can order investigation, but subject to, what are the circle subject? There are two things. One, that magistrate, before ordering this, they must receive a report containing facts and circumstances which are leading to the incident from the officer superior to him. So suppose there is an allegation against one sub-inspector of a police station. You approach the magistrate court CGM asking the CGM Detective Department Calcutta Police to investigate. Magistrate can do this order, but before giving this order under clause A, because it was done by the sub-inspector, magistrate may ask some report from the inspector. Magistrate may ask a report from the assistant commissioner. 2. After considering of the assertion made by the public servant as to the situation that lead to the incident, that magistrate will also hear that police officer. So after hearing that police officer, after getting report from the superior officer, then the order shall be given. Now, this again created some kinds of obstruction in filing cases when the perpetrators are public servant, public officers. So, we can say in other word, or what the government views are, that they have put additional safeguards. So many times this safeguard should not become an instrument to give impunity to the public servant when they indulge into illegal behavior or when they indulge into doing illegal act. So that's the what the cross is there. So you find obstructions are created in certain circumstances. It's a good or bad, you can judge. You can judge about its advantage, disadvantage. You have to do research. You can find research. You might sometimes do project. You can go and ask the police. You can ask the informant, etc. What challenges they face or how these provisions are really helpful or not helpful. So this power of the magistrate to direct for investigation is a enormously powerful provisions and which frequently used. I said in the magistrate court, many junior lawyers or many lawyers who working in a magistrate court, for them this 156 clause 3 is butter and bread. So they get lots of cases like this. So power of magistrate to direct investigation. And the court says the under 156 clause 3 to direct investigation is independent of the power to take cognizance. Magistrate has the option, they may take cognizance 200 CRPC. Now that become 223 CRPC, BNSS. But they can direct also to examine. Hence, there is no requirement of magistrate to examine complaint. Oh, there is no requirement. If they are taking a complaint, then for directing for investigation does not require anything. Prerequisite for exercise of power. Application under 1 clause 3 without affidavit duly shown by complaint cannot entertained by the magistrate. So court has laid down some additional safeguard. Now this has been incorporated in provisions also. Now under the BNSS, what we have seen 175 clause 3, they added this requirement that there is a requirement of submission of petition by affidavit, and that's incorporated. So that these two, 173, 174, 175, these are the power of investigation. Now 176 onward is all talking about the processes in which the investigation being carried out. Now there are very detailed long sections are there. Some things we will skip. 170, so 173 FIR is registered. Now police has to investigate. What they will do? So when they receive this information either under 173 or 175, he shall send report to same magistrate empowered to take cognizance upon police report and shall proceed in person. So either OC will himself do investigate or they will depute subordinate for purpose of investigation. And which subordinate? As the state government may declare. So like in West Bengal, even in some cases, ASI can investigate. So depending on the situation, the law can permit the officer who can investigate. And they will proceed to investigate and if necessary to make measures to discover and arrest the offender. It was earlier also written in the CRPC. So that also written here also under 176. So they may go to find out materials, they may go to arrest the persons, they may go to discover materials, etc. Then there's a proviso provided that when the information as to commission of any such offense is given against any persons by name and case is not of a serious nature, the OC need not proceed in person or depute a subordinate officer to make investigation on the spot. If it appear to officer in charge of police station that there is no sufficient ground for entering an investigation, he shall not investigate the case. Provide further that in relation to the offense of rape, recording of the statement of the victim shall be conducted at the residence of the victim. That's the basic rights of the victims. And or the place of the choice of the victim. So either at the residence of the victim or place of the choice of the victim. Some victim might say that, no, please don't come to my home. I'm going to other place, my friend place, come there to record a statement. Possible under the law. And such statement may also be recorded through any audio, video, electronic means, including mobile phone. So the victim statement can also be recorded by video conferencing. That possible under the law. So now you will find almost every places in the BNSS, this use of technology has propagated. Not mandatory, But many times it says, and I think it's a good that these provisions can be useful. In each of the case mentioned in clause A or B to first proviso to subsection 1, officer in charge shall state his report the reasons for not fully complying with the requirement of subsection by him and forward the daily diary report to the fortnightly to the magistrate. So the cases where police says that we will not investigate, there is no materials. Now those reports fortnightly they have to send to the magistrate. Clause 3, on receipt of every information of commission of an offence which is made punishable for, this is new thing. It was not there earlier. And very important thing. So on receipt of the every information relating to commission of an offence which is made punishable for 7 years or more, the officer in charge of a police station shall, from such date as may notify within a period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect forensic evidence in the offence and also cause videography of the proceeding, etc. So the new concept has started, new beginning. Now law mandate that in every case says where punishment is more than 7 years, we must use forensic scientists. We must take services of forensic scientists for collection and preservation of evidence. Now, I may mention here, I told you there was a committee established in 2001. In 2003, they have submitted report, Malimat Committee. You can just Google, you will find Malimat Committee report. In Malimat Committee report, that point of time, they had given a recommendation, and in one places they add the word SOCO, SOCO. So in SOCO, Malimat Committee says scene of crime officer. So idea of Malimat Committee was when there is any offence being committed, immediately a police team will reach, special reach. In that police team or special team must have forensic expert also, and they will help in collection and preservation of evidence. So what was suggested in 2003 by Malimat Committee, now we see in 2023, this act has mandate, but then it put 5 years embargo that within 5 years, state government will notify as and when it is going to be enforced. And there's a reason. The reason is that still we have not that much manpower or facilities for forensic science. When we wanted to use this evidence in all cases, then we require one forensic lab in almost every district because there are many cases where the punishment is more than 7 years. It also says if the forensic facility is not available in one state, it can take help from the other state, etc. Those also possible. Now, delay in sending the report, merely delay sending the report itself cannot lead to conclusion the trial vitiate, accused entitled to be acquitted. That's not the thing. Then 177 says sub report was submitted. So once they did this investigation, etc., they will submit their report. So every report sent to the magistrate under subsection 176 shall, if the state government so direct, submitted through such superior officer, etc. So they may through inspector or maybe AC or the DSP, that it will be reported to the superior. We are not that much concerned of this procedure. 178, power to hold investigation or preliminary inquiry. When magistrate do that, get this report, may direct for investigation, or if he think fit, at once proceed, or depute any magistrate subordinate to him to proceed to hold a preliminary inquiry into. They can investigate or they can hold preliminary inquiry. A police officer power to require attendance of the witness. So that's basically now that comes for the statement recording. Remember, it was earlier 160, 161, 162. So these are 3 sections for police, or even 163. 160 gives them power. So suppose some of you are acquainted with some case. So say Sirisha, just next door, some offense being committed, something happened, and she was watching from her window, or he was Muhammad was watching from some other gate, etc. Police came to know that there's some neighbor who was taking video, some neighbor who was taking record, or some neighbor was watching. Maybe some offense happened on the road, and from the window or etc. they were watching. Under 160, police has power to ask them to come and give a statement. So this is the section which gives them power to require attendance of the witness. So police think that anyone who is acquainted with the facts and circumstances of the case, they can call them. Police think I came to know about some incident and I'm aware about it. Police can send me notice to come and give a statement. Any police officer making investigation on this chapter by order in writing require the attendance before himself of any person being within the limit of his own area. So they can send notice and they can ask. Then they put a limitation that if the persons to whom they call, if that person is a aged or a woman or a physically disabled person or a person of acute illness, it was not there earlier, now it has been added. So terminal illness, cancer patient or some similar thing. Then they shall not be required to come to the police station, but then attendance at any place other than the place which such persons reside. So they have to go there and. But one thing added is the proviso is a new thing added, and this proviso says no. But if those persons want to come to police station, there is nothing harm in. So that's the law also says. And then the rule making power. 180, which is basically main provision of recording statement. So under 179, it's the power to call. Under 180, they can record the statement. Clause 2 says, if they're asking some questions, the person is bound to disclose. So suppose one of you has been called by the police to appear as a witness. So say Ankona Ghosh, her local police station sent her a notice that she came to know about some incident. Now the law mandate under 160, they have power to call in writing. They will give notice. Under so it was 160 earlier, now become 179. 161 under which now become 180, under which they can record the statement. And they put an obligations that whatever question being asked, they should give true answer. If they not give true answer, that consequences are there, except the only exceptions are which cases the person is not bound to answer. The cases which expose them to criminal liability, because everyone has right against self-incrimination. No one can be compelled to disclose something which is going to incriminate them. That protection is given under clause 2. So the constitutional protections that has been extended here. So such person shall be bound to answer every question related to such case put to him by such officers, other than questions answered to which would have a tendency to expose him to criminal charge or to a penalty or forfeiture. So if police ask any question which going to answer of which going to be criminate, then you can say sorry, I cannot reply. So this right against self-incrimination, it start even from the stage of investigation. Very famous case, Nandini Satpathy versus State. Supreme Court made clear that these rights which are there under 161 and 160 or under the Constitution, these rights are started applicable even at the stage of investigation. So, if the question is going to tend to criminal liability, the person is not bound to disclose under 180. Clause 3 says the police officer may reduce into writing any statement made to him in course of examination under this section, and if he does so, he shall make a separate and true record of the statement of each such person whose statement is recorded. It also says that if police thinks the statement recorded under this section may also be recorded by means of audio, video, electronic. So it can be videograph also. It can be recorded by video conferencing, that possible. Then these are the sexual offenses. So when a statement is recorded by sexual offenses, now in those cases, who will record the statement? What shall is there? Women officer. That's the law mandate. So it was 161, that become 180. Any person in subsections include an accused persons also. Many times accused statement can also be recorded. 181, statement to police and use thereof. Remember, the statement we made to the police. Now, these statements are not substantive piece of evidence, but it may use for the purpose of contradictions. So here they laid down about what kind of a use it is. So 181 says, no statement made by any persons to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed. So there is no requirement of signing. Provided that when any witness is called for prosecution in such case, inquiry or trial whose statement has been reduced to writing as aforesaid, any part of the statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witness in the manner provided in 148 of Bhartiya Saksha Sanhita. So it can be used for the purpose of contradictions. So they can contradict. Then it says, nothing in this section shall deem to apply to any statement falling within the provision of clause A of 26. What is clause 26? It is dying declaration. Now, it's not only this statement, 180 statement, it's applied to 173 also. Victim came to police station for recording statement and she got injury. Immediately her statement was recorded, a fire was registered, police also recorded statement. Took her to admit in hospital and then she died. Now, what E-FIR become? E-FIR become dying declaration. The statement which she made to the police under 180 become dying declaration. Once it become dying declaration is an enormous value. We say dying declaration are substantive piece of evidence. Our convictions can be based solely on dying declaration. Very important evidence. So that's why it says that nothing will apply in respect of 26. That means dying declarations. It has added an explanation and omissions to state the fact and circumstance in the statement may amount to contradiction if the same appear to be significant and otherwise relevant having regard to the context. So that's basically explanation what kind of a contradictions can come, etc. in the court. So admissibility of confession made to the police. Remember, confession to police inadmissible. Law is very clear. Earlier it was in Evidence Act section 25. Now it is there section 23 of the Bhartiya Saksha Adhiniyam. 182. No inducement to be offered. If police recorded any statement by use of any inducement, threat, promise, etc., then that confession are inadmissible because evidence law itself says any confession obtained by inducement, threat, promise, irrelevant, inadmissible. Now, very interesting thing. When we make law hurriedly, many times we omit something. There may be omission. That's what happened clause 1. See very minutely this clause 1. Clause 1 says, no police officer or other persons in authority shall offer to make or cause to be offered or made any such inducement, threat or promise as mentioned in section 22 of Bhartiya Saksha Adhiniyam. Interestingly, this word inducement, threat, promise was there in section 24 of Indian Evidence Act. In 22 of Bhartiya Saksha Adhiniyam, they added one more word, that is coercion. So now 22 of Bhartiya Saksha Adhiniyam says inducement, threat, coercion, promise. Now here they forget coercion. So the different set of people prepared the draft and you find this omission. So when they added these three words, they should have used coercion also, because if you look section 22 of Bhartiya Saksha Adhiniyam, the word coercion is there. So now it is inducement, threat, coercion, promise. These four things are there. Clause 2. But no police officer or other person shall prevent by any caution or otherwise any person from making in the course of any investigation under this chapter any statement which he may dispose to make of his own free will. That basically provision, nothing shall provision subsection 4 of 183. 183 is basically for magistrate. So that's the 182, where basically the idea is that when police will record a statement, etc., no coercion, etc., they should be used. Now come to 183. 182 inducement. 183 is a statement recorded by magistrate. Earlier it was 164 CRPC. So when a magistrate records statement, now this statement is recorded during investigation. So any witness who are important for the case or accused confessional statement, it can be recorded under 183. Then a law categorically says this confessional statement can also be recorded by audio, video, electronic means. Now there are some new thing has been added. That is not willing, he can withdraw. Now magistrate has to satisfy that the person is giving voluntarily statement. One of the technique which the magistrate use is to give reflection of time, because the accused is being produced from the police custody. There might be apprehension of torture, etc. So what they do? Normally they segregate the accused from police, and those, so we call it reflection of time. So magistrate asks them, okay, just wait for one day. You reflect whether you really want to confess and come tomorrow. Tomorrow again he said, no, I want to confess. The magistrate can record the statement. When a magistrate record statement, magistrate is certified that he explained everything to the accused, that he is not bound to disclose. If he disclose something, it will be used against him. And then he is satisfied that he is making a statement voluntarily, etc. That certification given by the magistrate. Because they give these certifications or certificate, they ensure that it's done voluntarily, etc. What the magistrate usually do is, they give reflections of time to the accused before making confessional statement. Clause 5 says any statement other than confession made under subsection 1 shall be recorded in the magistrate hearing before for the recording of the evidences. So, with the magistrate thinks in the case of base fitted for circumstance, magistrate shall have the power to administer oath to the persons whose statement is so recorded. So, magistrate can, by oath also, they can record the statement. Then they have laid down the safeguards. If some places you require a special educator, they need to arrange special educator. If a statement is made by the person who is mentally or physically disabled, then those statements shall be recorded by through audio, video, this shall be, apart from that, interpreter is required, and that shall also be recorded by audio, video, electronic means, so videography is required. The statement recorded as subsection A of a person who is temporarily or permanently mentally or physically disabled shall be considered as a statement in lieu of examination in chief, so that will become evidence directly. The magistrate recording a confession or a statement under this section shall forward the magistrate by whom the case can be recorded and tried. Now there are other changes, two more changes are here. One change is, when a statement is the record of a women, of a victim of rape, etc., women statement is being recorded, it's mandate that such statement shall be recorded by women judge, and if not women judge, that in presence of any women. Evidence confession clause 5. Then also they have added one more thing, where the offenses is more than 10 years, and if police brought someone for recording of the statement, magistrate shall record that statement. So that's also is given in this act. Recording of the confessions. The magistrate will take precautions to ensure that the police influence, if any, is removed before recording confession, but sooner it is made, the better. So that basically reflection of time. If the magistrate has to satisfied that he is coming from police custody, might be torture, etc. So what they do, magistrate give them reflection of time, and thereafter they record the statement. Alok Dutt, admissibility of confession. Now remember, for confession statement, there are two main tests. Any admission or confessions. One test is voluntariness. Second test is truthfulness. If the court is satisfied about truthfulness, voluntariness, they can rely upon. So confession ordinarily is admissible in evidence. It is relevant fact. It can be acted upon. Confession may, under certain circumstances and subject to law laid down by superior court from time to time, form the basis of conviction. It is, however, treat that the said purpose, the court has to satisfy itself, one, voluntariness of the confession, truthfulness of the confessions, and sometimes corroborations also required. What will happen when there is a retraction? So suppose a person has went to magistrate, given confessional statement, and later on retracted. Let us say, no, police has tortured me, that's why I given this evidence. What those value? Now the court will decide whether someone retract does not mean that the completely it is not admissible. So the retracted judicial confession is a weak piece of evidence. Nature, admissibility, and consideration of retracted judicial confession is require corroboration. Court has to satisfy. But then court also in many cases says non-retractions are exceptions. So many times when accused arrests someone, police arrested some accused and brought before the magistrate for recording of the statement. Now magistrate will give some reflection of time. So sometimes magistrate send them where they will keep. They cannot keep in police custody. It should be judicial custody. So the magistrate will send that accused to the jail, sometime for 2 days, 3 days, 4 days, and ask them to come after 3 days or 4 days. Now the longer the period, the chances of that he will again confess become minimal. Why? What is jail? Jail is a university for criminals. So when they go there in the jail and when discuss with fellow criminals, they will give advice that better don't confess. If you confess to magistrate, you will always be in jail. So when they come back from the jail, they don't confess. And that's in practice, it's happened in many cases. But yes, so that's why we suggest to magistrate normally, we should not give very long time for these reflections of time should not be longer period. If these are minor discrepancies cannot be treated as a non-corroborative factors. So now we come to medical examinations of the victim. It was earlier 164A, now become 184. Now what was there in CRPC 164A? The same thing is there in this law. So remember when it was included in the CRPC, two sections was added simultaneously. 53A was added for the medical examination of accused, and 164A was added for the medical examination of victim of sexual offences. What's the difference between these two? The difference is the medical examination of accused, the law says that medical examination, if the accused being taken to the medical for the hospital, etc., they should give medical examination. Suppose the accused is refusing to give medical evidence. Law says 53A CRPC said police can use force. But for victim, consent is required. Victim medical examinations cannot be conducted without consent. Because there might be many reasons for which victim may refuse to give medical evidences. For example, might be a male doctor is medical examining. Victim might not comfortable to do medical examination. So there is a possibility. So 184 is talking about the medical examinations. Now, when these two sections came, that was again very important section. There's a new concept brought in, and that says that if the government hospitals are not available within 16 kilometers radius, then preliminary medical examinations can be conducted by any registered medical practitioner. That means any MBBS doctor can do preliminary medical examination. What's the reason? Reason is that in sexual offenses cases might be in the initial stage, you might find some bruises mark, you might find the semen, etc. And through that, the DNA examinations can be conducted, which may help in identifying and proving the case against the perpetrator. So why we do? To find mark of injury, general mental conditions, other mental particular, etc. for DNA, etc. The report shall specify the record that the consent of the women has been obtained. The exact time of the commencement and completion of examination also need to be mentioned. There is an obligation that the registered medical practitioner shall send back report within 7 days time. So there is a timeline, outer time limit within which the report need to be sent to the IO. So very important provisions. Now, one very interesting omission. When we look at, we have seen already in the arrest chapter, when you have seen section 53, 54, 52 on medical examination of the accused. Now, there we have read, law categorically says that if the medical examination of an accused, if the accused is a female, then medical examinations shall be conducted by female doctor. Now, the rape victim will be female only. Now, here the same thing is not been mentioned. It's a omission. When they added there in the BNSS, they should have added here also, but they have not done it. Yes. So earlier it was 167. Now this clause 2, wherever you find this red color, these are new changes. It was not there in the old CRPC. Now, earlier concept was that when an accused person is being arrested and brought before the magistrate can send them in custody. So custody they can send to the police back. So police they want for police remand, we call police custody. Or if the police has not asked for police remand, then it can be judicial custody, jail, or unless the court is giving bail. So general concept was that in any cases, the initial time they give police custody, and once the police custody from where the persons came back to the court and the person sent to judicial custody, they don't give police custody again. Now that concept has changed. Under the new law, it says the magistrate can send in any custody. That means both police custody or judicial custody. Police custody total period cannot be more than 15 days. It was earlier also, there is no changes in the days. When it can be given? It can be given initially 40 days or 60 days. 40 days where the charge sheet timing is 60 days. Means where the punishment is up to 10 years. 60 days where the charge sheet timing is 90 days. Punishment is more than 10 years. Even in cases when a person got bail and may submit an additional application for cancellation of bail, and after cancelling the bail, the police custody can be granted. So law permitted. So this is a new change in respect of the custody, which was earlier. From the old law, there is a new law, there is a significant change happened in clause 2. Clause 3, earlier the word was very clear that other than police custody, so initial 14 days police custody and thereafter jail custody, now that concept has gone. So 90 days, 60 days, 90 days where the punishment is more than 10 years, 60 days where the other cases where punishment is less than 10 years, etc. Within which otherwise the person has entitled to get bail. So we call it statutory bail, right of the bail. Bail we will discuss when we discuss about the bail in another class. So this is the provisions for the discussions. Now, many times when conferencing, the custody can be extended. Clause 5, second class magistrate, we don't have in West Bengal second class magistrate. Explanation 2, proviso has been added. provided that a case of a woman under 18 years of age, the detention shall be authorized to be in the custody of a remand home or recognized probation institution. Now, it was earlier also, they have added, but what is there need? Now we have Juvenile Justice Act. And under the Juvenile Justice Act, if the child is a person is below 18 years, they cannot be produced before magistrate. Magistrate court has no power. It has to be dealt by the Juvenile Justice Board. So in my view, this proviso was not required. They have added here. Now, very interesting last proviso. It was not there. It's a new thing. What the new thing is here? It says, provided further that no person shall be detained otherwise than in police station, under police custody, or in prison under judicial custody, or place of declared as prison by central government or state government. What's the need of arises? We know there's a police custody, there's judicial custody. One is they added this just to avoid any kinds of things which of the Nolakha kinds of situations where the horse arrest can be there. So what the horse arrest possibility, which was just taking shape, has been completely killed by this law. So there is nothing called horse arrest after this, and that's why they have added this provision in the new act. Clause 6, it does not apply that much. Which talk about in cases where judicial magistrates are not available, then the persons can be brought before executive magistrate who can extend custody. Now remember, in our system, judicial magistrates are always available. Even holidays, judicial magistrate sits in the court. So this section, it was earlier also in CRPC, but it rarely used. It's not of that use. That basically custody provision. Clause 9, if a case trial by magistrate as summoned case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offence. PMLA, whether it's apply or not, the provision of these sections, the procedure contained therein applies in respect of the special statutes. Now remember, for special statute, the general rule is where there is a conflict between the general law and special law, always special law prevail. So some provisions of CRPC will apply. Thus, not only in there is no provision in PMLA, Act excluding applicability of CRPC. So whether PMLA is silent, the CRPC will apply. Remand of the accused, now remand concept has changed. It was earlier 167(2). Vikramjit Singh, State of Punjab, right of default bail. We send within 90 days or 60 days. So 60 days where punishment is up to 10 years. If the police do not submit charge sheet, a police report, the accused has a matter of right, is entitled to bail. We'll discuss more, we'll discuss about the bail. 188, report of the investigation by the subordinate police officer. They can submit report. This is a procedural requirement. Release of accused when evidence is deficit. When there is no evidences, the accused can be released. When there's evidence, then what to do? Then person may be sent for further proceeding. So their cases can go for trial. So 190 says cases to be sent to magistrate when evidence is sufficient. So when evidence is sufficient, under 170 they will send to the magistrate. Basically, this is the section which says they will make up their mind, and they find that enough materials are there to proceed, they can send to the magistrate. Now, this is new proviso has been added, and this is very interesting. This proviso says there are many occasions when a person has not been arrested and police is going to submit charge sheet. So what was earlier they used to do is that before submitting charge sheet, they used to arrest and shown arrest to the accused person only for the sake of charge sheet. Non-law categorically says this proviso that only for charge sheet police don't require to arrest. So what they can do, they can take undertaking from that accused that the accused will appear as and when the court will call them. So no requirement of per se arresting someone only for the purpose of submitting police report or charge sheet. That's what the 190 suggested. 191, complainant and witness not to be required to be accompanied police officer. So there is no requirement that the complainant should go along with the police. No unnecessary restraint, etc. 192 is a diary. This is about case diary. Remember, in the police station, there are two kinds of diary. One we call case diary, other we call general diary. This is here, it is talking about case diary. So this case diary maintained for each cases. So every day, all the development about the case we will find from 192 of the 193. The most important sections of this chapter. So one section, the most initial section was first section FIR, and where the FIR, when FIR start, it will end into 193. So remember, the investigation journey begin by 173, end by 193 police report. So 193 is a provision for police report, and what it's required, clause 2 talk about in some sexual offences cases, the police report shall be submitted within 2 months. Within 60 days, that's the timeline which has been given by the law for submission of police report. Earlier it was only rape cases, etc. Now the POXO cases has been added. In these cases, the police should submit their police report within 60 days. Now, what if police do not complete this investigation within 60 days? There are no consequences. Then this police report, what the content should be, they have given a long list. So name of the parties, etc., etc., will find that is given in this police report thing. Now, some new thing has been added. One new thing is the sequence of custody in case of electronic device. So in cases of electronic device, basically electronic record, etc., the custody sequence that need to mention in the police report. H1, 2, 3, all threes are very important. Now, when you just look at this provision, one, electronic record sequence need to be mentioned. This is right, basic rights of the accused. What is the rights of the accused? Victim. This is the first time in the BNSS they introduced a concept that police must inform the victim progress of investigation within 90 days. So we can say as a very important rights of the victim has been included in this section. 3, the ways communication will be made that the state government will by rule prescribe. So that's the provision of charge. Other are the process what could be there in the charge sheet, etc. Not in that detail. When this police submit police report, in court they will submit as many number of police report which required to be given to the different accused. So it will save the time. But then there's a proviso added. What proviso says? Provided that supply of report or any other document by electronic communication shall be considered as duly served. Now, the someone, suppose the charge sheet is 1000 copies, 1000 page document, and the accused is in jail, and the police send the copy by email, where he will get access, where he will get document. So yes, in some cases they may send by electronic communication, but always not very good. Now, clause 9, the further investigation which I said, the first time they have introduced that even when the cases was at the trial stage, and there's a requirement of further investigation, police think there's a more investigation required. It provided that further investigation during the trial may be conducted with the permission of the court. So court can give permissions to complete this further investigation within a period of 90 days. So there is a possibility of further investigations under the new law, charge sheet, in the form of charge sheet. When police asking that, okay, no enough evidence are available, the accused must be discharged, we call it final report. So there is a two form in which the charge police report can be submitted. Direction of Atul Rao, direction of further investigation can be given. Now, thereafter, we have these sections which talk about basically in case of suicide or homicide cases, we call it a process of inquest. And thereafter, police can send for medical experts, so they can do again examinations, inquest, find out the real cause. So medical expert can do entire postmortem, etc. But initial thing done by the police under 174 will now become 194. And thereafter, they will send to the hospital. So he shall, subject to such rule, state government may prescribe in this behalf, forward the body. I am reading this second paragraph. With a view to it being examined to the nearest civil surgeon or other qualified medical person, I am appointed in this behalf by the state government. If the state of the weather distance admit of it being so forwarded without risk of such putrefactions on the road, act would render such examination useless. So initial examination, inquest done by the police. Thereafter, police forward to the body to the hospital for medical examination. Arjikar, same thing happened. The following magistrates are empowered to hold inquest, namely DMs, SDM, other executive magistrates, etc. When they do this inquest, they do have power to ask someone to appear, summon someone, call someone, get their view. So executive magistrate they do inquiry. Then some protection has been added, it's newly added, that when they call there, if there is a child, then they should be attended at any place other than the place where such persons reside. If they want to come to police station, they can come. Inquiry by magistrate in cause of death. So when the under 194 police do inquest, they can forward in some cases to the executive magistrate or near magistrate to do inquiry. They can do inquiry under 196. In some cases, the inquiry by judicial magistrate becomes necessary when there is a case of disappearance, rape, custodial rape, etc. Then it's the judicial magistrate who can do inquiry. And then they will submit report under this section. So earlier it was 176. Now it become 196. So these are the circumstances when they do inquiry. So that's the basically chapter we will see from 173 to your last section 196. This entire chapter talk about your investigations done by the police, and the last three sections after 193, 194, 195, 196 These are in respect of the dead body examinations, etc., which they can conducted in those circumstances. So initially by the police, then it is done by the executive magistrate.